He shot that guy in the stomach.
A night of violence and chaos in the streets of Kenosha ends with 2 dead and 1 injured.
People are just getting shot everywhere, guys.
On August 23rd, the Wisconsin city is catapulted into the national spotlight. Outrage explodes after the officer-involved shooting of Jacob Blake. A portion of that interaction is captured on cell phone video that goes viral.
Asking people in Kenosha and around this nation to protest, but protest non-violently.
Night after night, the unrest continues, fueled by protesters and counter-protesters, among them 17-year-old Kyle Rittenhouse. The Illinois resident crossed state lines on August 25th armed with a rifle, telling local reporters he was there to protect property. By daybreak, he's a wanted man. Cell phone video from that night appears to show Rittenhouse running through the street as others race towards him. Some onlookers shout accusations saying he's the shooter, then more gunshots.
Oh, people are getting shot all around us.
Video from a different angle shows the gunman firing multiple rounds as he's surrounded by a crowd. He then walks away with his hands raised in the air in what seems to be a surrender. But law enforcement vehicles roll past him. The sheriff's office explaining he was likely overlooked in the confusion of that night.
The radio traffic was nonstop, and there were people running all over the place.
Investigators say the first fatal shooting victim was 26-year-old Joseph Rosenbaum, killed in a parking lot. Then, moments later, Anthony Huber, also 26, is killed in the second street confrontation. Lawyers for Kyle Rittenhouse say he acted in self-defense the night of the shooting.
And Court TV legal correspondent Julie Janae is with us tonight and has the latest on Kyle Rittenhouse and tomorrow's hearing.
Vinny, this just in, the attorneys for Kyle Rittenhouse have filed a motion to dismiss 2 of the 6 charges that he's facing. And here's a look at those 2 charges that they say there's not enough evidence that a reasonable person could determine there was a crime committed. The possession of a dangerous weapon by a person under the age of 18, that's one of the counts. And another count is the first-degree reckless endangering of safety through the use of a dangerous weapon. So those 2 charges are among the 6. We know he's also facing those homicide charges for the death of those 2 protesters. And probable cause is something that has been a top issue for this defense team. They raised it back when he was being extradited from Illinois to Wisconsin, where this crime or alleged crime occurred. They made those arguments during extradition, faced some criticism from the court and from prosecutors saying that that wasn't the appropriate time. So we expect that they are going to be bringing up those issues before the court at the preliminary hearing tomorrow. But it's unclear exactly what pending issues the court is going to hear. They did have witnesses lined up during the extradition hearing that they wanted to come in and talk about probable cause and what supported the idea that these charges are not based in fact. Now, we know that Kyle Rittenhouse's mother has testified before, Wendy Rittenhouse, so there's a possibility that they'll be bringing her again to talk about the details leading up to and after her son's arrest. We know that they have listed former detectives Todd Johnson and Steve Spingola to talk about the lack of probable cause during the investigation of this case. And they also have a self-defense expert, Andrew Branca, who will talk about in this case and what they have looked at as far as the facts that this, in the defense's arguments and opinion, was a self-defense claim. So that hearing tomorrow is going to be at 11:30 Eastern. It's going to be remote, so they won't actually be physically inside the courtroom, but it will be via Zoom. But Kyle Rittenhouse will be in front of the court for the first time as a free person.
Oh, that's right. He's out on bond, $2 million bond. Julie Janae, thank you so much. Let's bring in Court TV anchor Michael Ayala to go through some of this. Big day tomorrow, preliminary hearing. You never know exactly what's going to happen, especially with this defense team. What would you expect a good defense attorney to do at a preliminary hearing like this tomorrow?
All right, well, as Julia said, and she outlined it very well, he's going to be bringing in evidence, but that's not really what this preliminary hearing is about. It's about the prosecutors bringing in evidence to show that they have probable cause to charge Rittenhouse. And again, it's a very low standard. It's not beyond a reasonable doubt or anything. It's just more likely than not. So they'll be bringing in witnesses. Now, a good defense attorney, his primary goals are as follows. First, he's going to build a foundation to impeach witnesses at trial. So he's going to take those prosecution witnesses. He's going to make sure that he's listening to everything they say. He's going to cross-examine those witnesses, get them on the record with information so that possibly he can use that information against them later at trial. He's going to preserve testimony of the witnesses for the record. Again, that plays into number one. Anything they say will be on the record. That's something that he can study and work with so he can use it at trial. Number three, he's going to gather information for plea negotiations or for use at trial. Again, gathering information, because Vinny, up to this point, and you know this, the defense attorneys haven't really received a lot of information from the other side. After this hearing is when they start getting a lot of information. So this information at the trial, what these witnesses testified to, is going to help them with their case. And then finally, he's going to evaluate the strengths and weaknesses of the prosecution's case. It's going to allow him to see where it's strong, where it's weak, help him craft his defense. Now remember, when he brings his witnesses in as a defense attorney, the prosecution's going to be doing the very same thing.
You know, in this case, what's fascinating is how aggressive the defense has been. I mean, they've put out a video already, a 10-minute video demonstrating their view of the case and how it's self-defense. I'm wondering what prosecutors will do and what the judge will make the prosecution do in terms of witnesses. You know, will they put on the actual eyewitnesses, or are we just going to hear from the investigators who spoke to the witnesses? Because jurisdiction to jurisdiction, judge to judge, you know, the rules in a prelim can be, okay, yeah, we'll allow some hearsay, you know, and sometimes they do, sometimes they don't. What do you expect this prosecution team to do tomorrow in terms of whether or not they're going to put on the actual eyewitnesses or just the people who spoke to those witnesses?
Well, I will tell you, in Wisconsin, they have relaxed the rules of evidence for preliminary hearings. So you can bring in 100% hearsay if you want to. Now, a smart prosecutor will not bring in actual witnesses. He may bring in somebody not related to the case at all to read the arrest warrant, maybe show the video, things that are already sort of well known. And this doesn't allow the defense attorney then to cross-examine, because if the witness is only reading the arrest warrant and the information that was provided for the arrest, then they really don't have any other information that they can answer on cross-examination. So there is a possibility that they can do that. It's very, very helpful. By relaxing those hearsay rules, by relaxing the rules of evidence, it's very helpful to the prosecution's side.
Yeah, because you think about who the witnesses are here, right? The other demonstrators. And I think one of the key witnesses may be a reporter who was there, was the first one at the scene after the first shooting. Second shooting, we've got the video, so I would presume that they would put the video in as evidence. Now, someone else who could potentially be a witness in all this is Kyle Rittenhouse's sister, Faith, who spoke with police shortly after the shooting. Let's take a listen.
So at 10:18, when you talked to them, did you say where he was? This may sound like a silly question, but how do you know that he was in Kenosha?
I just hear the picture, but I don't want any location of him.
When did he say he was in Kenosha?
All day.
Interesting statement there about the medical, because we've heard this from the defense, is that, you know, part of what he was doing that night was acting as a medic. You know, all summer long at all these protests, like in Seattle and other places, you had citizens who were running around as medics. And he had the AR-15. How do you think the issue of I was there to be a medic would play ultimately in front of a jury?
Well, at the end of the day, Vinny, it goes to state of mind, right? The idea that why was he there? He went with an AR-15, but his own words say he was there just to protect himself, so just in case something jumped off. But he was really there to help out, protect businesses, and also provide medical help to anyone who needed it. So that could be helpful in terms of this idea for the jury to see why he went down there and what his state of mind was.
Right, because the one picture that's been played, you know, in a lot of discussions of this case, and people are very polarized on this case, by the way, as they are in everything else, right? But one thing people say, oh, you went there, you know, to shoot someone. He went there to kill someone. And, you know, how that plays in a courtroom, I don't know if prosecutors are going to go that far, but it seems like they may. They may actually say, listen, that's why he was there. He was there looking for trouble. Could you see prosecutors making that type of an argument?
I don't, Vinny. I really don't. I think there's a lot of statements surrounding his own statements, as well as the statements by his family members and friends that really are clear as to what his state of mind is going down there. As a matter of fact, I think there were even conversations earlier in the day with police officers, some of those gentlemen who were down there with guns and were down there supposedly or allegedly to protect businesses and help out. So I'm not sure that they would have much success making that argument. I think they're going to have to really focus on the circumstances of the actual confrontations.
Now, Kyle's sister went looking for him in Kenosha, and they're in Illinois, but it's relatively close. When they came back after not finding him, he was already home. Take a listen to how she described Kyle Rittenhouse, hours after the shooting.
What happened when you walked in the door?
Kyle was on the couch, sitting on the couch, and he was crying. And we asked what happened. He was like, I'm getting attacked. So I had to shoot.
That's consistent with an argument of self-defense that you're going to make. The question is, what does the testimony of the witnesses line up with what his version is?
That's really what it's going to boil down to. Again, he's a 17-year-old boy. He shot someone. I can't imagine the amount of emotion he's feeling when he realizes the gravity of what he's done. So certainly he's crying, and he certainly felt under attack, and that's what his mindset was, at least at that point. So the jury will sort of deal with that. But again, it's going to boil down to the witness testimony in those individual confrontations. And I heard you mention earlier, or mention yesterday actually, that it's that first confrontation that we don't have a truly clear picture of that's really going to be the important confrontation in terms of the witnesses, what they saw, and how he acted there.
How many more details do you think we're going to learn? Because, the defense has been very public with this, but prosecution really hasn't. How much do you expect to learn from tomorrow's prelim?
I don't think we're going to learn a lot more than we already know. I think there's plenty of probable cause just by looking at the video. That is not a decision a judge is going to make in that courtroom. He's going to allow that decision as to whether he acted appropriately on that tape to a jury. So there's plenty of probable cause there. So I think the prosecution will be smart to just do the minimum, to get over that hump, that very low level hump of it's more likely than not that a crime was committed, and then let the case move on. So prosecutors are not going to want to give away a lot of information because that just gives ammunition for the defense to help preparing their case.
Yeah, I think you're right. I think the big wild card, though, is what will the defense do? Because this team, more unpredictable than any defense team in the cases that we're tracking right now. Michael Ayala, Court TV anchor. Great to see you tonight. Thanks so much.
Thank you.